Companies that are contemplating engaging in M&A activity should think about whether or not their house is in order, not just as to these parties or this transaction, but more generally, the sort of documents that are going to get produced to the agency. And now, not just documents that will be produced as part of second request or maybe a voluntary access letter, but documents that will be produced upfront and what those documents may reveal. Document hygiene is more important than ever. A lot of firms have reviews in place based around the prior HSR rules to make certain that there's no misrepresentation or inaccurate suggestions in those documents before they go to officers or directors. But now those sort of reviews need to be ongoing and much broader.
In 2009, DOJ opened up several investigations and filed civil enforcement actions against tech companies for entering into agreements not to compete for each other's workers. And these actions were significant for really two reasons. First, it made clear that companies may not compete or make or sell the same products can nonetheless compete in labor market. And second, it established that DOJ views agreements to allocate labor markets no differently than agreements to allocate markets for customers or for territories. And this sort of led to 2016 when the FTC and DOJ issued their joint guidance to human resource professionals, in which both agencies committed to vigorous enforcement of antitrust laws in these markets. DOJ maintained going forward it would consider two types of conduct for possible criminal prosecution: the wage fixing, agreements with competitors not to compete on terms of compensation or benefits, and no-poach agreements. And DOJ said it would focus on naked agreements, or those not reasonably necessary to any separate legitimate business collaboration between among employers. So what does that mean? Let's take that in context on how you might advise clients, taking into account on whether you should really audit on whether a company has entered in any agreements with its competitors. And as it relates to the compensation side, simply put, do not enter into any formal or informal agreements with your competitor to lower or maintain worker compensation. One thing I would do is be aware of a company's benchmarking effort and the gathering of market intelligence, because there is a risk